I hereby call the January 4th, 2015 Zoning Board of Adjustment meeting to order at 1:30 p.m. and establish a quorum is present. We need to take action related to the minute record of the regular meeting held on Monday, December 1st, 2014. Have the board members had an opportunity to review the draft of the minutes from December 1st, 2014? I just now received these minutes, so I have reviewed them very quickly, but I'll admit, not entirely. Give me 1 minute. Did all the members of the board receive these minutes in a packet this week?
Yes.
Did anyone not receive them? Okay, I guess I was the only one that didn't receive them, and I couldn't find them on the city's website. I got the agenda, but not the minutes. Are there any changes that need to be made to these minutes that anyone can see? Okay, do we have public comment about the minutes? Mr. Wardlaw?
Yes. I have 3 proposed changes in the minutes, Mr. Chairman and members of the board, to accurately reflect what happened at your last meeting. The first one would be on page 2, I guess, over there. I see Mr. Sam Allen, attorney, is shown as an attorney of record for this, but I don't show Guy D. Choate, who's also attorney of record for the appellants, some of the appellants. And I just think his name ought to be added there for housekeeping purposes.
Should we make that item 7 under A? Is that what you're requesting?
Yes, sir. Be fine. Guy D. Choate with a law firm of Webb, Stokes, and Sparks.
You spell that name C-H-O-T-E?
C-H-O-A-T-E.
C-H-O-A-T-E?
The second one is over there on top of page 3. It says, Mr. Wardlaw explained that the city is supposed to give him appeal papers. That is not what I said, and I think when I tell you what I said, you'll remember it. What I said was I was pointing out that the city planning department and Mr. Howard were not following the ordinance, in that the ordinance requires that Mr. Howard immediately, and I'm going to give you the citation here in a second, but that upon receiving the appeal notice, he's supposed to immediately furnish copies of all the appeals papers, consulting the record. He's supposed to give that to you immediately. And if you'll remember, we filed the appeal 33 days prior to our last meeting, and so the question was, people were speculating or tongue-in-cheek were saying was 34 days immediate delivery to this board. And if you'll remember, Fred Adams actually read into the minutes the actual section we're talking about, which is 2.07.063. And so I would like for it to reflect that. I never asked that the appeal papers be given to me. I was the one that prepared the appeal papers. I drafted them, and I filed them along with Mr. Jesse Martinez. And also we had Mr. Howard's papers, because he had written his appeal decision in a letter to Jesse Martinez, and we had a copy of that too. So I wasn't seeking anything. And I might just make one additional point. here you people had not received these papers for the appeal, which to me is important that you have those as soon as you can, so you'll know what's going on. And I think what happened was, and you know this better than I would, but I think they, after the last meeting, they ran over there and got copies of the papers and delivered them to you. I think that same day, but maybe later on. I saw that written somewhere in a timeline that they had delivered the papers to you, but it was after the last meeting. So I would like that correction to be made.
That's a rather lengthy correction there. Do you by any chance have that sort of condensed and reduced to writing? I do remember it that way.
No, sir, but I can do that in just a minute. Or I can dictate it into the record.
Does anybody on the board disagree with what Mr. Wardlaw has just said that he said the last meeting?
I think that's the way I remember it, and I think we can actually verify that off of the tape that they have of this meeting. They do have a record, and that is also an official minutes of this meeting by the Open Records Act. So that is an official minutes of this meeting as well. We need to make the paper one agree with that. And I move that we tentatively approve the minutes with the corrections and changes proposed by Mr. Wardlaw after it's been, and that it be brought back to be finally confirmed at the next meeting after it's been compared and verified with the video record that we have, so that we make sure that, because it's easy to make mistakes on something like that, and I think that would be a good way to make sure it's correct.
Mr. Wardlaw, before we get a second here, do you have any further corrections?
Yes, I do. It'll just take a second. I think some important conversation needs to be included in the minutes that took place right at the end of our last meeting, and I know you all will recall this. I got up toward the end of the meeting and made the request that each and every one of you board members please go out and visit the Pinnacle Sands frac site off of Hughes Street, and I gave an explanation as to how to find it, and I made that remark and then sat down. And then after I sat down, Attorney Sam Allen got up and said he had no problem with the board members going out there and observing the frac sand site on Hughes Street. And then I recall Mr. Allen sat down, and then after that, I recall and know that this happened. The city attorney on her own objected to my request, which had been agreed to by Mr. Allen, and instructed you to not go out there and observe the frac sand site on Hughes Street. And I think that needs to be included in the record.
All right, hold on just a second. Yes, sir.
Yes, if I might address the chair. Dan Slurry, Senior Assistant City Attorney. The minutes of our meeting, of your meetings, are not verbatim transcripts.
Yes, sir.
So generally what's included in the minutes, and not refuting anything that's in the record, which is recorded and transcribed. The minutes, could properly reflect that Mr. Wardlaw addressed and brought to the board's attention Section 207063 of our ordinances, which relates to when and what information is to be turned over to the board. But to go through and try to reiterate and itemize specifically statements that were made to you is not usual, has not occurred in the past.
Yes, sir.
The purpose of the minutes is for a summary. The exact record is available to the parties and to everyone else. No one's trying to, not refer to the record. And there will be a hearing, and what is the record is the record. But for purposes of the minutes, we don't normally put specific statements in the minutes.
I think the board will agree with me on that. Mr. Wardlaw, we all, the board agrees that that's what we heard, what you're saying now. Is it somehow of major importance that get itemized in these minutes?
Yes, sir, I do believe it is, and I believe Attorney Mr. Choate agrees with me on that, because that is one of the big issues that we're going to be talking about here when we talk about the proposed amendment to the bylaws, is whether or not you have the right to go out there. And of course, the bylaws clearly say that you do, and that was pointed out at the last meeting. And you know how the city attorney can come up with a ruling so contrary to the state law and the bylaws is shocking to me. As
Well,
been an attorney for more than 40 years, and I think this needs to be in there. I think
Okay.
it could be material to our to the record later on.
Okay, before we make our motion, let's,
Mr. Allen, I think, wants to have
Okay.
the right to respond.
Was that all three of the things you had to?
Yes, sir. That's all.
I'm Sam Allen. I represent Southwestern Orient Properties and Mr. Pfluger, its principal. We're the appellee, the person defending the appeal. The only clarification I'd like to make is on the proposal that the board visit the Barnhart site. I did not approve that, and I would recommend against it. The point being that that site is not a site being operated in compliance with light manufacturing zoning.
yes, sir.
And so the issue is whether this site can be.
Well,
And
we're
so,
not,
The rule about what the board will review will be determined today, and I understand that, and we'll comply with it. But I just want to make sure that wasn't a surprise. That's
Yes,
my
sir.
position on that. And if it goes into the minutes, if you'll reflect that, I'll be happy. If it doesn't, I'm okay with that as well.
thank you, sir.
Thank you.
Whether or not that goes in the minutes has no bearing on what we're gonna do. If it's important to Mr. Wardlaw, I think we'll put it in the minutes. Jeff, can we itemize it a little better? Go back over it and, you get that in the minutes that way?
Absolutely, yes.
Way, Mr. Turner. So, Mr. Turner, would you like to change your, motion any, or?
I move that we approve the minutes with the changes requested by the parties that have spoken before the board.
Second.
All right, motion made by Mr. Turner, seconded by Mr. John. All those in favor?
I've got a
I'm sorry.
item of discussion. As you stated in your comment, that these represent a condensation of the meeting at some level and speak to major points. That being said, that obviously someone bears the responsibility of saying what was germane and what was important. And I think that's the issue here, is that something that one of us may have thought was very important be in there, and another person will think, yeah, okay, so we talked about that. And so I think that's what creates the differences in opinion on this. And as long as what they're including is something that's verifiable on film, I can't see why having this particular set of minutes be a little more voluminous is an issue. So I would be in favor of including it.
And I don't think this sets any precedents. I agree with the way we've always done the minutes, but as I think everyone knows, this this particular case is a little bit more delicate than most all of them that this board hears. So, we have a motion and we have a second. I'd like to always vote by show of hands. All those in favor? It's unanimous. The minutes will reflect Mr. Wardlaw's changes and otherwise approved.
Does that not speak to Mr. Allen's?
Yes, it does, and Mr. Allen.
Okay, and Mr. Allen's. Okay, item number 3 is is in relation to the ZBA case 14-41 regarding an agreement of the designated parties of interest regarding the time and date for an appeal hearing on property described as 5.510 acres tract occupying the J. Ebert Survey 680, abstract 0172, number 39 Orient Branch City and SAISD in San Angelo, Tom Green County, Texas. More specifically, that the designated parties of interest for the special alleging error in the determination of the Planning and Development Services Director that the proposed silica frac sand operation is permitted in the light manufacturing zoning district, agreed to a hearing date of February the 2nd, 2015 at 1:30 p.m. before the Zoning Board of Adjustment. Staff, could we have a presentation?
Sure, Mr. Chair. Simply, at the last meeting, there was some discussion about the concern about the February 2nd date. This agenda item essentially gives you the ability to confirm that the date that was established for the public hearing, February 2nd, will still be a valid date. And if there are any concerns, this is an opportunity to make any changes as necessary.
Thank you, sir. Is there a representative for the designated parties of interest in attendance who can speak on behalf of everyone?
With regard to the designated parties, we have no objection to that date. Now, there are obviously perhaps hundreds of citizens of the city of San Angelo for whom I don't speak, and I want to make that clear.
Yes, sir.
I'm here on a pro bono basis for the 5 designated parties, but that date's fine with us with regard to those persons.
Okay.
Sir, could you state your name for the record?
My name is Guy Choate, and I'm with the law firm of Webb, Stokes & Sparks here in San Angelo.
Thank you, sir. At the December 1st,
Mr. Allen? This is an opportunity to confirm the date if there's an issue, so we just need both sides to.
Currently, that date is acceptable to the appellee, Southwestern Orient. There's an open question about what type of evidence is going to be proposed and when it's going to be presented to the board. We assume that will be manageable, something we can still get our minds around by that date. With that assumption, we agree to that date.
thank you, sir. At our December 1st, 2014 ZBA meeting, Monday, February 2nd, 2015 at 1:30 p.m. was chosen as the date and time for an appeal hearing on the property as previously described. That date is agreeable to all parties. If there's anyone that disagrees with that, okay.
Let me ask you a couple of questions. In the last meeting, Fred Adams, I believe, said that he could not be here on that date. Is that still stand as far as the staff's aware?
I think he was talking about today.
Today, okay.
That's correct.
So it's not the February meeting.
That's correct. Mr.
And-
Turner is correct.
In the last meeting, the city attorney didn't actually say that she would be out of the country, I think. Do we know what her status is for
We
the
do.
February meeting?
And she will,
She will be here at the February meeting.
correct.
Well, question, suppose that Mr. Adams is not here or the city attorney is not here. That doesn't affect our going forward in any way, does it?
No, sir, it does not. It only affects you all if there's not a quorum.
Thank you.
Move to approve the date?
Do we need a motion for that? We've already set the date, so there's no reason to,
The agenda doesn't clearly establish that that's an action item, and I think your minutes that you just approved, it was unanimous for setting that date, and there's no objection. So
Okay.
it's not an action item.
Okay.
okay, the public hearing for case ZBA 14-41 is hereby set for February the 2nd at 1:30 p.m., 2015. Item number 4. Item 4 is a consideration of the adoption of a resolution by the City of San Angelo Zoning Board of Adjustment amending the bylaws of the Zoning Board of Adjustment, more specifically by amending Article 5 entitled Conduct of Meetings, more particularly by amending Section 5.10 in order to allow the orderly submission and reasonable opportunity for board member review of documents prior to an appeal hearing, providing that the board may act only upon evidence properly admitted into the record, and providing for an effective date of this bylaw amendment. Staff, could we have a presentation?
Yes, sir. Patrick Howard, Planning and Development Services Director. There was some discussion at the last meeting or concerns about the ability to provide information prior to the hearing. And so this resolution before you essentially proposes an amendment to the bylaws which essentially affords you the opportunity to provide documents for review prior to a public hearing date. And you should have the language before you, but I can read that verbatim in terms of the modification or the addition to the bylaws that provides that such opportunity.
Please read it.
Okay, prior to a hearing, this is section 5-10, which would be the proposed amendment. It states as such, prior to the hearing, parties may file documents in support of or in opposition to the appeal with the board secretary with sufficient copies for each board member. Board members and any party may review such pre-filed documents prior to the hearing. At the hearing, each pre-filed document shall be identified by the chairman to determine whether the filing party would like to offer the document into evidence. If offered by a party, documents shall be admitted into evidence in accordance with this section. Pre-filed documents that are not admitted as evidence and made part of the record shall not be considered by the board. The board may act only upon the basis of evidence properly admitted into the record at the hearing.
Thank you. Is there a member of the public who wishes to speak on this matter?
I'm Guy Choate. Here's a member of the public and as a representative of these 5 folks that I'm here pro bono. I'm not being paid by anyone to be here. First off, the representation that this just allows us to kind of have an idea of where we're going and what's going to be presented. This proposed amendment goes vastly beyond that. Everybody on this board is here and has been appointed because someone on the city commission or city council believed that you brought a certain background, experience, training, expertise to this board that gave you a unique insight into the job that you're about to be confronted with. What this says is that you're not to act in that capacity. You're to act as a judge, as someone who merely acts on a record that's put before them, and that's how we do it in the legal context. At best, the law is clear in Texas and has always been clear in Texas back, into the 40s and 50s of last century, that the kind of board you are is quasi-judicial. There may be an attorney on the board, I don't know. But if you were appointed, you weren't appointed as an attorney. You were appointed as a member of the Zoning Board of Adjustment, which is, in a broad sense, a political appointment. And you're not asked to park your common sense at the front door. And let me just agree with Mr. Wardlaw. Anybody who says you can't or should not go and see what a transloading sand plant looks like, that is not consistent with state law. Absolutely. It is not consistent with your obligation as a member of the Zoning Board of Adjustment. And it's not consistent with our city. And it's not even consistent with your own bylaws, which says you are strongly suggested that you go out and you look at what you're doing. Now, the suggestion's going to be made that the sand plant on Hughes and the sand plant in Barnhart have nothing to do with the kind of sand plant that's proposed in this instance. Well, if that's true, then the burden certainly is upon these folks to prove that, because I think, you know, you don't need to get out of your car driving by the Hughes plant or the Barnhart plant to understand that it is a nuisance. It is not light construction. And that is something, as a member of the Zoning Board of Adjustment, you can go see for your own eyes. And this would say that if we show up and the record, quote unquote, of which there's only 5 people here being involved, there are literally hundreds of the citizens of City of San Angelo, if not thousands, who are deeply invested and opposed to this. But if the record somehow didn't indicate a document that explained what goes on out there, that you couldn't use your own common sense and what you've seen, you're going to believe the record, you can believe my lying eyes. I went out and looked, I saw that you've got to leave all that at the door and only rely on that record. That is not the law I would suggest to you. It is not what this board should adopt. And there is no necessity for this. There's going to be a lot of people here at that meeting that aren't represented by council, but who deeply care about what's here, and this board needs to hear those folks and has an obligation to hear those folks. And those folks have an obligation and an opportunity and as a right as citizens of the City of San Angelo to come in and make their voices heard. And so I think the adoption of this proposed, what looks to be, oh, well, that's only fair, we'll just do what's in the record. If I'm a lawyer, I absolutely agree with that. From a legal standpoint, that's what I do every day. But this is not a purely legal hearing. This is a quasi-judicial proceeding, and each of you have your obligations to act as per your own bylaws. You're strongly suggested to go look at these things, and we ask you to use your common sense and not try to comport it to some constraints that simply aren't supported by the law or the facts. Thank you.
Thank you, Mr. Choate. Mr. Allen?
I'm Sam Allen, I represent Southwestern Orient, Mr. Pfluger. The rules in the city code that pertain to this proceeding are in essence a mirror or verbatim of the rules in the local government code. And it's clear that a record is anticipated in there. In fact, it's mandatory in the instance of an appeal from this body to the state district court. So I don't see how this body can make a ruling without referring to the record and the facts from which that ruling is made. So to the extent that the ruling that we anticipate in February is going to be made by this body, I think it is in keeping with some of the most basic tenets of our law. That's got to be based on facts that were presented that you, as the board, deemed trustworthy and admissible into evidence, and that it needs to be, that those facts need to be established in a public forum, a place where folks can listen to it, can observe it. We would also hope that we'll be given the ability to cross-examine witnesses presenting evidence or to present countervailing considerations. And I don't see how you can do that without having that evidence presented at one time in a public forum in a record. So that's my response to Mr. Choate's comments. I think you are a judicial body, and I think that's simply something that is something you just have to do when you're going to fulfill that function. With regard to submission of materials prior to the hearing, we don't necessarily have an objection to that. We want to make sure that we can, we'd appreciate it if a copy would be served on us. If we need to check every day for a submission, we'd be glad to. We just want to see what's presented to the board or what evidence that the board reviews that'll be taken account of at the hearing. And as far as any pre-designated timelines that I mentioned earlier, we don't necessarily have to have them either. We just want to make sure we can understand what the board is evaluating so that if there is evidence that could counter it or that we feel is also relevant on the point, that we can present it. It'll also streamline the hearing somewhat to conduct it in that fashion. So that's our response to that.
I agree. Before you leave, sir, Mr. Howard, everybody's going to be privy to this, any information we receive, anything that this board's going to go over. Is that correct?
That's correct, sir.
Okay, so that's what you're just addressing.
Well, we'll be
Am I-
privy to it if it's described in this forum.
Yes, sir.
I don't want to be accusatory in term, but just by way of example, if on a Sunday afternoon he felt like it'd be a good idea to drive down to the Eagle Ford and look at a frack sand facility 20 miles outside of Three Rivers, and nobody knew that, and it wasn't mentioned here, and a decision was made based on what was gathered or observed on that trip. I don't think that fulfills the concept of a public forum.
Okay.
And so we just want to make sure we know what's being considered and that we have the ability to show evidence that might point otherwise on that particular topic.
Okay, before you leave, sir, does the board have any questions of Mr. Allen?
Yeah, I do.
Okay.
The way this is written, it appears to me that the responsibility falls on the chairman. It says, at the hearing, each pre-filed document shall be identified by the chairman to determine whether the filing party would like the document into evidence. If someone has furnished a document, letter, whatever, what other reason would they have done it if it wasn't for evidence?
Mm-hmm. Yeah, I think we're talking about two different things here. If there's a letter or a photograph or a videotape of another facility, someone's wishes, their interpretation of the statute, and it's provided to the board, that comes to this meeting, and the chairperson says, I have this letter, and I want this admitted into the record, then I have no objection with that. But if, to the extent that you may be invited to go and make your own inquiries and to keep them to yourself or to give them any weight in the decision that'll be made in February without allowing the parties to know your thought processes, I think when you put your judicial hat on, you're not supposed to do that. And it's not that we second guess anybody's integrity. It's just concepts that everybody doesn't deal with in everyday society. So that's really what I want to make sure I know when this is over, what all you looked at to make your decision.
Sure. Fair enough.
But the mechanics of this are what's bothering me. I'm John Q. citizen, and I have an opinion about the sand thing. And right or wrong, I've decided that I want to put my opinion in the form of a letter and submit it. Okay, so do I mail it to the planning department? Do I mail it to the city? Do I hand it in? Do I give it to David at a cocktail party? I mean, how that happens. And then at lunch, he does it at lunch. At that point, if I give him that, now it's his burden, his responsibility to take the thing in or to get it submitted, as would be for all of us if we get something. I mean, how would the public know that if they want to file or register evidence or a complaint or a viewpoint or a whatever? I mean, it looks to me like we're creating a tremendous thing here, because what we're basically, you're going to have to make a written record. It's going to have to get in the minutes. The chairman's going to have to approve its inclusion, and then we're going to discuss it. To me, you're simply building a wall and making it as hard as possible for there to be public free public comment. I see this as nothing more than a way to block public comment.
Well, Mr. Rourke, in all due respect, the time for public comment has passed. There are specially designated parties to this particular proceeding, and that door is closed.
Well, okay, for the public to have input, I'm going to put testimony, evidence, whatever.
Mm-hmm.
Mr. Rourke, I think we can clarify your concern. It actually is not an issue that Mr. Allen should address. Staff has proposed a draft amendment, and we can explain in detail the impetus behind the intent of the language. So I'm going to allow Mr. to Larry to explain some of your concerns that you had about members of the public, not parties of interest, but members of the public providing information regarding the case.
Yes, thank you. The item that we are under discussion on is a proposed bylaw amendment. That bylaw provides for prior submissions by parties. You've already identified the parties, and that is just sort of a housekeeping, organizational type bylaw provision. As far as contact with the public, and I think you had this reviewed at your last meeting as well. That's the reason for the public hearing, and the public would come forward, at that hearing. If they have something in writing, then that could be presented, or submitted, but at the hearing. Again, as has already been stated, you are in a quasi-judicial capacity. So you don't go out and conduct an investigation or rally for one side or the other or any of that type of thing. You try to keep a clean, open mind to consider evidence that's properly submitted at the hearing, and that would be your function. But this bylaw just permits a party, we've already identified who the parties are, to do pre-submissions. They're not automatically admitted into evidence. You still follow your same process for admitting into evidence, and that is the chairman would decide it, and then the board could overrule the chairman if you disagreed with the chairman. But each item would be considered as, is this evidentiary or not? Will it be admitted or not at the time of the hearing?
Which sets up a deal of if David approves 6 things or rejects 6 things, then we got 6 votes. After that happens, if someone else on the board does. Why, we've reduced 100,000 people down to 6 or 7 on the board, and now we're reducing that board down to 1. We're saying that the chairman will make the determination, and if the board disagrees, then they can vote.
Well, I mean, I don't believe this part is a change, but it's the first part of that section 510. The way that it reads is that the board shall not be bound by strict rules of evidence, not limited to consideration of such evidence as would be admissible in a court of law, but it may exclude irrelevant, immaterial, incompetent, or unduly repetitious testimony or evidence. And then the next sentence, the chairman shall rule on all questions relating to admissibility of evidence, but may be overruled by a majority of board members present.
I think that's what I just asked.
Right. Right.
And sir, that's currently in the bylaws as
That
is.
is your
This is
bylaw.
that's not an amendment proposed. That's currently in the bylaws. What we're proposing is based on the conversation regarding evidence being able to be provided or potential evidence being able to be provided prior to the hearing. This amendment addresses that issue.
That's addressed in the memo from December 4th and or 5th.
Yeah, I've read it.
Want to address that further?
No. If you're happy having that whole burden, that's fine.
To
I
the
do
city,
have a
to
question.
the
Okay.
board
That I-
members.
Wait a minute, Mr. Wardlaw.
I would like some, at least some clarification, that if any of us individually drive out to either of those locations in operation, we are not to do that, or we are to document it and let everybody know that we have? Could you clarify that, please?
Well, for clarification, and it is pretty clear that a quasi-judicial body is not the investigating body. Now, but what you know about your community and what your background are, you don't leave your common sense at the door, and you take your experience with you. And that's about as far as I can address that question.
Ms. Cunningham,
Wait.
have you investigated or have you driven out to the sites and looked at them?
No, have not.
Okay.
Mr. Chairman, may I address her, Ms. Cunningham's concerns and rebut some of the things that we're hearing? Let me first let me read the bylaws. Mr. Choate referred to them earlier, and if you are not allowed to go out there and observe this process, then we're not going to have due process, and this is going to be prejudicial to our appeal. It's just that simple. But let me read you the bylaws and not try to talk about judicial. This is
Can I
not
ask
a
you-
judicial proceeding.
Mr. Wardlaw, can I ask you a question before you go into this further? Mr. Turner brought up a good point earlier to me, but what about video evidence? If you want us to see this, why can't you just take video evidence and submit it as evidence at the hearing, and we'll see it?
That's a good question, and I've got a good answer to that. We are going to do that, and we are going to have video evidence, but the reason that we want you to go out there is twofold. Number one, a lot of this happens at night, and there are material things that you can see at night you can't see during the day, and that is the plume of silica sand dust that comes out of the top of these frac sand trucks when they're being filled up, and it goes up about 30 feet high.
So you're wanting us to go see this at night?
Yes,
Well, can you not put that on a video from at night?
it's difficult. We do have a little bit of it, but that's point number one. And point number two, these things, that facility out there and that operation is so massive, a video can't do justice as to what it does and how it would affect the community, I promise you. I've been out there between 40 or 50 times, and I get people to go out there, and they're just overwhelmed and shocked at what they see out there. And when you go out there at 10 o'clock at night, like I have, and you see 30 trucks out there idling on the property, waiting to be loaded, you can't. They're stacked in there. You can't see that on a video, and they're all there idling, making tremendous noise. And can you imagine that next to your front door at your house? You got to go out there and see it. But let me just. That's a great question, and I anticipated that was going to be asked. But let me just read the.
Excuse me, Mr. Chair, let me just remind you that item 4 is about consideration of amendment to the bylaws. So we just need
Please don't
to,
interrupt me, sir. I'm making
Mr. Chair,
I'm making my rebuttal.
I just want to remind you of item 4.
I'm
Okay,
going to let him speak.
this is section 12.03 of the bylaws. It reads as follows. Board members assigned to a case are strongly encouraged to visit the subject site and become especially familiar with the details of the pending request so that they may share their special insights with the other board members at the hearing on that matter. It doesn't authorize you to go out there. It strongly encourages you to go out
Sir,
there.
we've always been strongly encouraged to go visit sites
Right.
as a board, but this was explained to us in a meeting or two ago that this was a different type of case. This is an appeal, and different rules apply. Again, I'm not an attorney. I believe I've already said that, but
You can
we're
consider.
just doing the best we can
Right.
to get everything in order.
Well, you're getting the wrong advice, I would submit respectfully, Mr. Chairman. And just look, the city attorney is not here today, and what did she do at the last meeting? She instructed you not to go out there, when that's totally contrary to the bylaws.
Sir, wait a minute. You're incorrect in that she instructed us not to go out there on our own. We can still choose to go out there as a board. We can move this whole meeting out there and look at it if we want to. And if we need to, we might just do that. If your video evidence is not enough to convince us or make us understand, we'll do whatever's necessary to make a right decision, whether it be for you or the applicant.
I don't think that's what she meant, but I'll just say this doesn't say here in the bylaws, doesn't say whether you have to go out there as a jury, and that's what Mr. Choate was saying. This is not a judicial case. This is quasi-judicial. And let me just read you the Texas law about a judicial case. The judicial body, the body is not bound by ordinary rules of evidence and has broad latitude in determining the value of property for taxing purposes and may consider any circumstances which tend to show value. This was a appraisal board, and it's just critical that you be allowed to go out there, and what Mr. Choate and I are seeing, that this is just a Trojan horse where they're trying to exclude evidence, limit evidence, and you guys want to take all the evidence that you can garner to make the right decision for this city. And excluding evidence can be done at the time it's presented, not pre-excluding it, and that's what they're trying to do.
Okay, well, we've heard that, and I appreciate your input on that. We're going to discuss it. You'll have a chance to speak again if you need to. Mr. Allen, one more time.
Thank you. The only clarification I have is that the revision read by Mr. Wardlaw invites the board to visit the subject site, and you're always welcome to visit the subject site. It's right here on Hill. It's the property that is before you now. I think that's a very important distinction.
Thank you, sir.
Okay. That is, I guess, make sure you understand, that's not the Barnhart site or anything here. That's the site that is under consideration.
Okay. Before,
One slight response.
yes, Mr. Choate?
Yeah. Anything that we intend to present, that we present to this board, we will certainly present copies to Mr. Allen at the same time that we present them, just as I would in any judicial proceeding. It's just, it's required in what we do as lawsuits, but it's certainly a courtesy which every lawyer understands, and which I'll certainly give to Mr. Allen. But again, I just simply make the point, this proposed amendment goes far beyond just making an effort to organize the evidence that's going to be before this board. It really tries to hamstring and straitjacket this board to put aside what you simply know and the reason that you've been appointed, and to only apply certain limited evidence, and that is just simply not consistent with Texas law.
Okay. Let me have just a minute here.
Can I ask you a question?
Yeah, in just a second. Where we went down this road, I thought, in the first place because of Mr. Rourke's question about how are we supposed to read all this evidence and properly go through everything, and it was Mr. Wardlaw that seemed to be pushing that wanted to have us read things and not to try to quote Mr. Rourke, I'm paraphrasing, but didn't you say, sir, that we don't have time, or we might not have time to read 40 pages of something all in one hearing? That would be good if we could have that ahead of time, look that over, and examine that evidence. And I was under the impression that that was more of something that Mr. Wardlaw, Mr. Choate, even though he wasn't here, wanted us to do. And now you seem to be against it. I'm not quite understanding.
No, sir. No, sir. We do intend to get it to you as early as we possibly can. We're just saying that I don't want to stand here for perhaps hundreds, if not thousands, of San Angelo citizens and have this board adopt a constraint on their rights. And we don't want the situation to develop where this board feels limited in what your obligations and what your rights are as members of this board and citizens of the city of San Angelo, to make yourselves aware of all the facts. That's what we don't want to limit. We just, from a standpoint of being persuasive, we want to get things to you as early as possible. So it's not, no one's trying to hide the ball. We just want to be sure that we don't, by some amendment to an ordinance which goes far beyond just getting the right evidence out there, but tends to constrain you in what you make your decisions on. No, that's not our effort at all. We will try to get you this information as early as is humanly possible, and nothing's going to change about that.
I thought that you were suspecting that the other side would be trying to hide the ball, and you wanted to make sure that we saw everything, that you get to see everything, and so forth.
I've been to these sand plants, sir. I don't think they can hide that ball.
Okay. Mr. Rourke, would you like to speak to that?
Mr. Chair, if I could add, if I could clarify again, this proposed amendment based on the discussion of the last meeting addresses only the parties of interest in this public hearing. It doesn't address or limit the ability of the general public to provide information at the hearing. This is only for the parties of interest to provide documents prior to the hearing in February, as you've established. So this is not addressing members of the general public, only the identified parties of interest that were identified at the December meeting.
Okay. Some of this may seem frivolous, some of it may seem silly, but if we're going to make an amendment here, we're going to go over it, give everybody a chance to speak, and talk about it back and forth, and ask those silly questions 3 times over if we need to before we make any amendments to anything. So that's what we're doing now. I apologize if I don't have everything in exactly what they meant and what the reasoning for this is, but I'm going to make sure I understand it before I vote. Mr. Turner, you had a question.
Actually, a kind of a question and a statement. Isn't the purpose of this so that we can actually, as part of the hearing process, be familiar with what's out there, what's going to be presented, and not have to go over everything in that one hearing, and maybe have to have an additional meeting, can continue the hearing so we can get this dealt with as quickly as possible, and not drag this thing out to where we're here next year doing exactly the same thing over this exact same case. Isn't the purpose of this so that we can get and review some of the information before we actually go into the formal hearing setting, so we know what both sides are looking at and proposing? Isn't that the purpose of this amendment?
Yes, sir, it is.
At the same time, why should we be limiting it? I can see separating the major parties from general comments, but why shouldn't we also have, as part of this, public comment prior to the meeting so we know what the sense of the public is also on this? Not just a group of lawyers and property owners that are already involved. Doesn't mean that that should be the major thing we hang our hat on, but I think that that is an important part of the whole decision process here. Determining whether or not this actually is what this city and our agreement is. This is light manufacturing. What is light manufacturing is really what we're talking about here. And that is one of the things that's on the table here. Where do we draw the lines? How do we determine this is light, this is heavy? And public input, not just from the parties of interest here, I think is important to that. And if we have to wait until the date of the hearing to get all of that, we're going to be here for a very long time. And I think some way to collect that and condense that is important to making sure that this process goes forward properly and everybody's interests are served. Not just property owners, not just residents right there, but this affects a lot more than just one piece of ground on Hill Street. Thank you.
Yeah, I would like to comment on something that's been bothering me. Since we are, as I said, in a way, we're now judging an opinion that's been written by the staff. And I don't know exactly who all on the staff was involved in the research and all that went along with it. I think you signed the letter. And maybe not, maybe someone else did. Doesn't really make a lot of difference. But the letter got signed. And I'm assuming in your doing that there was a measure of research which involved looking at some of these plants that are here, that involved impact on neighborhoods, that involved all these other things, since it doesn't say specifically that we can have a transloading facility. Yet we're not privy, at least I haven't seen it yet, maybe it's coming, what all went into the thought process on your side, or whatever investigation was made, or what all was involved there, what came about. And so with that in mind, then we're turning around here and doing something that says, okay, Lee can't introduce anything that he hadn't already turned in writing, and Guy can't do that either.
They'll be able to submit any evidence that they want to at the time, but
At the time, and then once that's done, that's done. And if anything else comes up or any additional evidence develops, or they have another thought on a process that might be involved, they can't come into the hearing and present it. That's the way I read this.
No, that's
No,
not the way I read it.
that's not true. What, if you look at the amendment again, it talks about pre-filed documents. The only thing that would limit a document that's pre-filed from not being admitted as evidence is you all deciding that it's not admissible.
I
So
understand that.
documents could be submitted at any time. If you want to go back to the comment made by Mr. Turner, this gives you the ability to review documents prior to the hearing. The bylaws previously didn't speak to submission of documents prior to the hearing. This gives you the ability to actually receive documents prior to the hearing. At the hearing, you will decide whether what those documents that you've received would be admissible or not, but you subsequently can receive documents from the general public in addition to the parties of interest at the time of the hearing, even if they weren't submitted beforehand. So there is no nothing precluding the parties of submitting documents after the hearing or at the time of the hearing. This only speaks to the ability to provide documents prior to the hearing.
So we're not limiting in any way a party's
Absolutely
ability
not.
to introduce new information
No, sir.
at the meeting.
No, sir, that is not what it says.
If I could just say one. B, or the second part of that, though, goes far beyond that. That is what limits your ability to use your own common sense to make a determination on this, and that is what I find most objectionable. You know, we'll get all the documents together that we can get together, and we obviously don't want to preclude anyone else. But that is simply not consistent with what a quasi-judicial board, which you are basically a political board, and how you are to respond. That is not consistent with state law. That is not consistent with your bylaws. It's not consistent with the city code, and it's not what this board should adopt, B particularly.
Mr. Choate, point of clarification.
Yes.
From what I'm hearing, the biggest problem you have is with paragraph B there. It says we cannot look at anything that is not submitted into evidence as part of the hearing process.
That's correct. And I'm just looking at state law for many, many years. You weren't appointed because you're an automaton or a judge or anything else. You were appointed because you bring certain background,
Yes.
skills, abilities.
Could that video that gets shot at 10 p.m. be submitted as evidence that would be, okay, good. that answers
Absolutely, and will be. Yes,
Okay.
ma'am.
The board will make a decision what documents would be considered evidentiary or not. The bullet only speaks to the fact that if the board, or the chair for that matter, makes a decision about a piece of evidence and decides that will not be considered evidentiary material, then that's your ability your right to do so.
Thank you.
It's just all B says.
Do we have any further comment? Yes, sir.
Good afternoon. My name is William Reese, and I'm here to talk with you just briefly about a big picture. It's interesting to sit and look at all the minutiae in the document, the rules and all that stuff. My background is a pilot in the Air Force, the Air National Guard, flying C-130s and 141s. As a pilot, if you get locked in on a single point, you'll die, because you've got to be extremely scan rich and keep the big picture, and that's what I've got in wanted to bring to y'all today. I've been out to Barnhart. I've watched the operation out there. It's just, in a sense, it's the best of American capitalism at work.
Sir,
Yes.
we can't hear any evidence right now. It only has to pertain to this amendment.
Okay, well, I'm sorry. I was just going to speak about the safety aspects of children in the streets and old ladies driving.
That'll be for the next meeting.
Okay, I'll see you then.
Thank
Thank you
you,
so
sir.
much.
And Mr. Chair, I want to just make the point that you all can elect to modify the proposed amendment however you see fit. This is staff's attempt at drafting a resolution amending the bylaws based on the conversations from the last meeting. So you all can act as you see fit.
Okay, we'll have discussion from the board now. Who should we start with? Ms. Cunningham, anything you'd like to input on this?
I think it's a very complicated subject, and to try to review all the applicable information during a set defined hearing is going to be very complicated to make that educated determination with that common sense factored in. I think there's a lot of elements to this. I still don't think I got total clarification as to whether we can, whether we can't go to the site. If we can watch a video of the operation, that should suffice.
No.
Then that
We'll
concerns me.
address that in a moment. Mr. John?
I wouldn't mind if y'all could bring up on the monitor the second part that they were talking about the part B.
That's that last sentence.
That's that last sentence there.
The board may, okay, is that all that's involved? I thought there
That's
was
the second
more.
bullet.
I thought there was more underneath that.
No, sir.
Okay. So the second bullet is the part where is that what they're suggesting that that we should not go to visit or go outside of what's presented as evidence? Is that what it's suggesting?
No, sir. Those don't really have. Don't relate to each other. I think that the second bullet infers what's applied, what's stated in the second in the first bullet. The issue regarding visiting the site was something discussed at the previous meeting. It has nothing to do with the item 4.
Could we not strike B completely? Does it matter? I mean, it sounds
Sir,
like to
you
me-
can elect to do whatever the board is inclined to do. Staff has worked to put something together for your review, and you all can elect to modify that, elect to not adopt those. What it does do, however, though, without this inclusion of some language relating to receiving documents, would not provide you the ability to receive documents prior to the hearing. And that was what we were trying to
B-
address.
Help me here. B doesn't seem to do anything but reiterate what's already been said in A.
Again, that was my statement previously, that it simply infers it simply states what's essentially inferred in the previous bullet. So again, it's your ability to look at the document and figure out what seems to be most appropriate and adopt it as you choose.
Mr. Allen?
Members of the board, I'm going to make this comment in the form of a question, and that question is, how am I, as one of the parties, as an advocate for one of the parties, to know what considerations you weigh in making your decision? Think about that. I'm asking you to, without regard to what this clause says. I'm entitled, I think, from both the U.S. Constitution and the local government code, to know what factors you weigh when you make your decision. How am I going to know that if they're not defined in some fashion?
But anything we
Now-
receive, you'll get the same thing.
Well,
So you'll know.
So using a hypothetical, it's going to sound silly, but it makes a very serious point. How will I know when to get in the car and drive to Barnhart? Do I meet you out there? Do I I mean, when are we going to go on a windy day? Or are we going to take scientists? Are we going to know how many microns of silica we're looking at, or whether it's even silica or limestone? I'm being a little difficult to make the point, and that is, it's important, and it's a basic foundation of this process that we're about to do, that everybody knows what was considered when the decision was made. Now,
This amendment, sir, though, has nothing to do with driving out to Barnhart. This is just receiving written evidence, which you'll be privy to.
I think what Mr.
Well,
Choate
there's-
wants, oh, excuse me.
There's been talk of driving out to Barnhart, but we haven't addressed that.
Okay.
At this point, we're not driving out to Barnhart.
Okay. What I understand Mr. Choate's argument to be is that after the hearing, if you just feel that it's the right thing to do to vote against this based on your personal experience with something unrelated, something that was never mentioned, he wants you to have the latitude to do that. Is that how I understand that?
That is 100% absolutely correct, because that is your job. That is what they have been appointed to do, to use their judgment to make that determination.
Now let me put,
If I might address the chair, there is a very fundamental legal principle for this item number B, which says that the board may act only on the basis of evidence properly admitted into the record at the hearing, and again, you decide what that record is. You're quasi-judicial. There's an appeal process directly to a court, which would be based on a record. There are decisions on those appeals in Texas that where boards have been reversed because parties have not been able to rebut or to respond to evidence that was considered outside of the record that they have no knowledge of. So that is the basis for saying you should hesitate, to become an investigatory body. You're not going to be presenting any evidence to yourself. You must rely on the parties to present the evidence. And so B is very elemental. It's something that you have to follow whether it's there or not. And it would be reversible error for you to consider evidence that all the parties and the public and any taxpayer that could appeal has no opportunity to rebut or respond to because they don't know what you considered, which is exactly what these parties are addressing here.
Thank you.
Correct me if I'm wrong, but even in a court case, a judge is available to review prior cases as part of his decision-making process. He's allowed to do a certain amount of independent research within certain limits, basically looking at precedent and other such things as that. As long as it is part of the record, it's clear what he did, how he did it, and why he did it, it's still a legal binding decision. Correct?
Well, examine the law in the way of the ordinance, the state law, court decisions, all that you want. And you don't have to report that to anybody. And you'll get a lot of argument on what the law is. It is an examination of evidence that you're going to apply, factual information, observations that you're going to apply in your decision in this case that is not the general, what the law is, but it is, you're going to make facts specific to this case. And what's fact specific to this case is the record. And you can admit whatever you desire to allow to be admitted into the record, but you must rely on what the parties bring to you. Of course, you have your own experience, your own background, your own knowledge. That's why you're here, just like a judge. You apply all of that. But you don't go out and conduct an independent investigation that none of the parties can really respond to because it's not there on the record for them to respond to it.
Let me ask you a question. The staff did this. They made a study, they made a recommendation, and they approved a zoning classification for a use. Now, Mr. Allen's saying, I need to know what y'all based your decision on. He's asking us, did you, on this, what weight did you give things and so on? Understand that perfectly. What do we get from staff? And this is why I was asking earlier about who's the attorney for who here. What do we get from staff that outlines a process of application, review, study of this, study of that, zoning ordinance, documents or records from other counties, use of the facility, and so on? Since we're being asked ourselves to be quasi-judicial, we're not just between them, but we're also in the process is this passing that's happened.
Staff would be making the presentation or has that option.
Who?
So Rebecca Guerra, Planning Manager, for the record. As part of the presentation that you will hear on February the 2nd, staff will be, in its presentation, we will be limited to giving you the information solely based on what our decision was based on, which is solely contained within the zoning ordinance. Everything that you will be presented on February the 2nd by staff will be contained wholly within the zoning ordinance. There will be no other evidence submitted by staff, that is the representative from the planning division, that will be based on any other material, on any other site, or any other factual information other than what was already presented to you by the director of the Planning and Development Services Department. No other information will be presented by staff. Our decision was based solely on the zoning ordinance, and the presentation that we give you will be based solely on the zoning ordinance.
Well, I have a little problem in, it's like the Bible. I have an interpretation and he has an interpretation. This does not speak to transloading sand. So you can't say you were not influenced by anything outside of the ordinance. If you were, there's nothing in the ordinance.
So I think that the hearing will provide an opportunity to deliberate on the merits of how staff went about their analysis. As the one being appealed to, we did prepare a letter and we did use the zoning ordinance as a basis for our decision.
Oh, sure.
So again, the hearing you have an opportunity to discuss and deliberate on the merits of how that interpretation was contrived, and you can elect to look at the actual interpretation and elect to decide whether that I was in error with the interpretation or not. I think that, and Ms. McGarrett eloquently suggested to you that that's what occurred, as we do every day as part of our responsibility to administer the zoning ordinance. And that essentially, again, this hearing is an opportunity to challenge how that was conducted, or at least what the result of such interpretation was.
And now what I'm asking is, are we going to be able to see your thought process presented in a format, not at the hearing, but before the hearing like everybody else? Right.
I would suggest to you that what we provided you already does provide insight as to how the interpretation was decided. We made reference to certain sections of the zoning ordinance, but the presentation in and of itself will reiterate those things, and look forward to providing that information to you next month.
All right, hang on a second. I want to ask the board if you have any more questions of anybody, of the public, of these attorneys.
Oh, for these attorneys? No.
Not of staff, of the attorneys or anybody, any member of the public. If not, I'm going to close this public hearing at this point. We've heard the same thing over and over.
What I have questions
You said it's for staff, right?
but it's part of the public hearing process.
We'll get back to that.
I'm confused on what you're asking.
We're going to close it to the public. At this time, no member of the public may speak or ask questions at this hearing.
You're closing the public comment.
I'm closing the public comment.
Okay.
Not to your questions, which would be directed only to staff. However, once a motion is made and seconded by the board, any member can ask questions of the staff as needed. Okay, we're going to talk about it amongst ourselves because we're hearing the same thing over and over, and we're starting to debate things that aren't the task at hand. I'm going to go first here and tell you that unless somebody here on the board changes my mind, it's still somewhat open, but I'm thinking that I'll vote no to this amendment. We just won't receive anything until it's time for the hearing. If we have to have another hearing or extend that hearing, then that's what we'll do. If we find it necessary as a board to visit one of these sites or anything else before we can make a decision, then that's what we'll do. But we'll do it after our February, or after or during our February the 2nd meeting. That's my opinion.
So you're against the amendment?
I'm against the amendment. But I'll hear everybody else's point of view. I can be turned around. I try to be open, but I'm against the amendment right now.
I think that's a lot to hear in one hearing. I think to have as much information ahead of time as possible.
Well, we're trying to start the hearing early is what we're doing.
No, I'm not saying today. I'm saying between now and February the 5th. Whatever we get in, it would be helpful to me to be able to review it before the hearing.
I think what we'll get into is making a decision before the hearing.
Well, they can still turn in stuff.
Well, I'm just giving you my opinion.
No, but I mean, I don't think you're voting against it to kill people from turning in information, does it?
Yes, sir. If we vote against this amendment. We can ask questions of the staff. Am I correct, Mr. Howard?
Chair, there is, if some version of this amendment is not passed, the parties will not have the ability to provide documents prior to the hearing.
I understand that. And I'm okay with waiting till the hearing to get those documents. That's me personally. We need either discussion or a motion.
We still have this discussion, and I've got some questions for staff that really has never been clear to me. Even though I've looked at the information you presented, and I was at the city council meeting when this was initially brought before council, one of the things that's never been clear to me is what information you actually had on this business, because you can't make this decision just looking at the zoning ordinance. You also have to have enough information on the business itself to fit in with that, and that has never been clear to me, and that needs to get clarified, and that needs to get clarified, I think, before the hearing. That type of information, because we're hearing things all over the place on how this business actually works and what it's going to be like there. And what factual basis did you have available to show you this is how much of a nuisance it's going to be, how much of an annoyance it's going to be, how much of a problem is it going to be in this area? And is that within what a light manufacturing zone should be? That has never ever been made clear. Yes, we have to go exactly by what the zoning ordinance says, but at the same time, we also have to know enough about how this business functions in order to say, yes, that decision, this zoning ordinance, yes or no. And we don't have that part, and I haven't seen anything that staff has submitted to us yet that gives us that information. That needs to be clarified before we get into the actual hearing itself. The second thing is, there needs to be some way to where we can get some of this information, even so we don't take up the first hour of the hearing just filing things in so we can put them in evidence. I think what needs to be looked at here is not that the evidence was properly admitted, but the evidence is properly considered and available to all parties. Some wording changes need to be done to this. But we need to be able to look at that evidence. It's going to take a long time with the amount of information that's going to be here for us to come to a good decision. And if we have to wait until February 2nd to start on that, we're going to be here for a couple days. And I'm not looking forward to that, and I don't think the public is looking forward to that. I don't think any of the parties are looking forward to that. We do need to have some way to we can legitimately get information in early and make sure that all parties know what's there, it's on the record what's there, because that's what will kill us and hurt the decision. If we can't back it up with something in the record, we don't consider it. Absolutely. But we need a way to have this information that comes to us early so we can get at least a head start on it. We need to have a way to make sure that that gets on the record, that gets considered, and everybody knows that's how we made the decision. The transparency of the decision and the fact that all parties' rights were respected, balanced, and a decision was a good decision. That's the important part here. And I don't see that this amendment is written doesn't do that, quite frankly. But the information we've gotten doesn't leave me feeling very warm either.
Well, with all due respect, Mr. Turner, it may take a day or two or three.
I agree.
This is not one of those things that we normally have. Usually we're out of here in an hour or two, not a day or three.
I agree. But I
mean, it's just the nature of the beast. It's gonna be what it is.
Sure.
And for transparency's sake, like you said,
Yeah,
I think we need to
absolutely.
take it all at the same time. We start looking at things ahead of time, and we'll have everybody wondering if we've been talking amongst ourselves, making our decisions prematurely, looking at evidence that was never admitted to evidence, and all sorts of things.
I'm not disagreeing with that. That's why we need to have a procedure. If we do put evidence in early, for some reason, it needs to be in such a way, it's a transparent process to where everybody knows during the hearing, this is what we looked at.
Right, and that's a difficult task, so I
Absolutely.
propose that we don't do it. We just wait till the hearing and take the evidence as it comes, and it takes however much time it takes.
I agree on that too, and that's a good way to do it. But the second part is, we also, I think, everybody needs to be prepared for all parts of this, not just the zoning ordinance, that little piece of paper there, because there's more to it than that. And we haven't had that yet.
Rick Wise, Assistant City Manager, and just to help address that a little bit, I was here at your last meeting and I've just come into working with the planning group. But as you stated, this is written solely to give the board the ability to review that if they want to. Patrick made an interpretation as the planning director. You stated that correctly. And his interpretation, he has background of why he did that with his knowledge. And he will provide that. At the meeting, he's not going to make some formal case against it. That's what y'all's job is. It's clearly written that if we don't agree with his interpretation, then this board has the ability to change that or overrule it or hold to it. So he'll provide that background that he provided on his decision, and then y'all just simply hear the facts and decide whether or not, in your opinion, that was a good ruling, or whether we just need to overturn it or keep to it. But if there's any other questions, we're here to answer those.
Thank you, Mr. Weiss. Okay, I think Mr. Turner and I have had our turn. Mr. Rourke?
I see the wisdom of having this beforehand. I certainly think that's important to have. I would like to have this stuff to noodle over and to look at and read and kind of think about different things that have gone into it. I do have some problems with part of this, and it may just be a matter of interpretation. I don't like to have a case in place and then have an amendment all of a sudden to the bylaws that's integral to what we're considering. It's kind of like changing the law before the trial. Although I do understand that a lot of people wanted to see this information, and I being one, before the hearing. So I don't know. I'm still up in the air about whether I'm for this or against it.
Mr. John?
Well, I agree with what you said as far as receiving information beforehand. For me, it's, I think, especially important. I don't have any kind of legal background or any experience in that. The only thing I've done, I've served on several juries, and on those juries, a lot of times they ask you not to go out and go to certain places and do certain things. So that's why, for me personally, I don't feel like I should go out to this other facility and take a look at it. I think I should wait until the evidence is presented. So that's my personal opinion on that. As far as this particular amendment, like I just mentioned, I need as much information as I can get beforehand. Like you said, to look over and think about. I would have preferred to have the closed meeting before this that was suggested, but so that the staff could go over some of the things that we needed to know beforehand in regard to this hearing. But it was decided that we should not do that. So as far as this particular amendment goes, I'm more in favor of having that amendment than not to have it at this point.
Ms. Cunningham,
I'm in favor of it.
do we have a motion?
I move that we accept the amendment as written.
Do we have a second?
I second it.
Motion made by Mr. John to approve the amendment as written, seconded by Ms. Cunningham. All those in favor, raise your hand. There's 3 in favor, all opposed, 2 opposed. I'm assuming that this is a majority vote.
No, sir. It needs to be a supermajority, so 4 of the 5 needed to approve it.
Motion fails. Okay. Our next regular meeting of the Zoning Board of Adjustment is scheduled to begin at 1:30 p.m. on Monday, February the 2nd, 2015, right here in the McNish Convention Center. Do I have a motion to adjourn?
Move to adjourn.
I'll second that motion. Mr. John, second the motion. All those in favor? Meeting adjourned.